authorities say, yeah, you can buy it, but only if you sell off 2 of your other companies. You're only on one side of the negotiation table. So push for it when you want it.
So I sold my company. We signed everything.
Congratulations.
Celebrated, so happy. Just to notice that, just a few days before closing, I got a notice just to find out that the company, the buyer, did not get the antitrust clearance.
Oh.
And now I'm standing here. No company is sold, and I'm taking all the money, the legal fees, the accountants, and everything I prepared. We scheduled 2 weeks of due diligence for the company, and it costs us a lot. And I have no money.
And you haven't sold the company. I thought you had.
Because I planned to do it.
Yeah.
What could I be doing in that situation?
Yeah, we're going to talk about solutions, some kind of protection for you as the seller in this case.
Which is called?
Break fee.
Yes, and termination fee also.
Termination fee, yeah.
This episode is powered by STG Corporate and Commercial Law.
If you hear that, it can be named different.
So what we're looking at in this M&A Masterclass are the negotiation terms that really, really boil down to money.
Yeah, so you don't stand there like I did.
Yeah. No boilerplates, no academics, no lawyers just showing off. What kind of terms can you negotiate for yourself that will really impact the situation, that will make it so that you don't stand there thinking you sold the company with nothing.
Yes.
Costs to cover only.
Yeah, even though we signed.
Yeah. So what we're talking about today, we're talking about, there can be a break fee or termination fee in the LOI, the non-binding letter of intent, because you have an exclusivity typically. That's not it. Right now, we're talking about the M&A timeline. So first we have the non-binding term sheet, we do the due diligence, we sign, and we close. And here we have things to do.
Yep.
Things need to happen, and that's why we sign and close at different dates. Sometimes in more simple deals, you can have signing and closing simultaneously. Yep. So in this case, we did not. In this case, I'm the buyer and I'm a competitor. That means that we need to file with the competition laws that they need to say it's okay for me to buy you.
So the authorities need to confirm that. Okay.
Antitrust clearance. And that can be other things. It can be a foreign direct investment directive. That you need clearance. It can be finance. It can be health. Anything. So, and conditions to closing can also be that you need to seek approval in a specific commercial agreement. You need shareholder approvals, etc. In this case, one of the conditions to closing did not work out, right?
No.
Because, if the authorities did not give antitrust clearance, I am not allowed to buy you, right?
No.
Okay. Bye-bye.
Bye-bye.
Sorry.
Not as I planned.
No. Yeah, because you were celebrating, drinking champagne, getting 25 million. Oof,
yes.
Right?
I celebrated a lot here.
So what can we do? Because you actually you feel that you had other buyers. Why did you go with me? You could have had a buyer who's not in the same industry, so this was not even a risk. But I offered 25 and the other one offered 24. But why did you go with me? And more than that, you feel that the application I sent and the actions I took, did I really, really try? Or is it the fact that the markets have taken a downturn and there are new tariffs involved that will hit your business that happen, so you might even think that I saw it a bit as an easy way out. But I'm right.
Yeah.
Condition to closing, I did not get the permits. What are you going to do?
I don't know.
Sorry. Bye-bye. Blame me all you want.
Yeah.
The condition to closing is not met. I don't have to buy you. Well, here's where the break fee comes in. This is why you should negotiate for a break fee when it makes sense. What you can say is that, okay, Mrs. Buyer, when you negotiate, I'll go with you because you offered me 25.
Yeah.
But, and you keep promising me, if we sign, we close. If we sign, we close. And it's a lockbox mechanism, so everything's clear-cut, you know everything. It's only a regulatory issue.
Yeah.
And you say, well, if I'm going to go with you, I want you to carry the risk. The costs, if the deal falls through, I mean, you're not going to get the share price.
No.
But you might get, let's say you argue for 2%. Suddenly you get your cost coverage and more. 2% of 25 million, and you can still turn around and sell the company to somebody else, right?
But you don't lose money.
Yeah, no. No cost coverage and some like a little
just a little bit.
pinch, like a penalty. Yeah, no, it's not allowed to be a penalty. But anywho, yeah. So you say, okay, the permit is your risk, not mine. I want you to carry that. So I want a break fee of 2% if we do not reach closing. And if I'm super sure that I can do what it takes, I'll say okay, because I promise you, if we sign, we close. And I know I'll get the permit. And you can even include a hell or high water clause.
Okay, and that is?
That is that I have to take any measurements that I can take in order to get that antitrust clearance.
Oh.
Otherwise, the break fee will happen. So, for instance, if the authorities say, yeah, you can buy it, but only if you sell off 2 of your other companies. Then I have to sell them off. Because I have a hell or high water wording in the SPA. So that way you have protection. And the break fee can go both ways.
Okay.
It can be a break fee and a reverse break fee. And what you need from both parties' ends is that it's very clear. What is required for me not to have to pay the break fee? So is it reasonable best efforts? Is it by a certain time? Anything. So it's not misused by any of the parties.
Oh, that's good to know.
Because you might see that I can actually sell this company for 35 or to somebody else. I might not want to go through with the deal. I might want to push you and I want the break fee, right? So it's very important, that's very clear when a break fee or a reverse break fee can be triggered.
Yeah, it's
But
brilliant.
use it. I mean, you're you're only on one side of the negotiation table. So push for it when you want it. And in particular, if the other party is like, I promise you, there's no problem. Okay, then. Then let's just have some safety mechanism for me.
Yeah, of course, that's so good. Because otherwise, don't be like me to forget about the break fee.
No. Break fee.
Break fee. Now you know about that. And it's so important if you're selling a business, thinking of buying a business, or if you want to work in the M&A world. I mean, this is a part of our must-know masterclass.
Entrepreneur, CEO, future superstar in the startup world.
Yes, at zero cost, we have a seasoned business lawyer here who takes us through what we need to know.
But it's not legal advice.
It's not legal advice. It's knowledge sharing as always.
This episode is powered by STG Corporate and Commercial Law, a boutique law firm for you to call when you need direct and personal legal support.
And until next time, rock on with your businesses. I'll see you here.
Hej då!
Hej då!